Hello, my name is Diane Cafferata, and I'm a partner at Quinn, Emanuel, and Sullivan, resident in our Los Angeles office. Thank you for joining my webinar about what I call killer motion practice. Over my 20 years of practice at the firm, my teams have handled a variety of complex business disputes, and in many of them, too many of them in fact, I've seen litigators on the other side of the V squander their time, their clients' money, and their own or their clients' credibility on weak motion practice. Motion practice really should not be viewed narrowly as just being about the relief granted in the motion. It's an opportunity to accomplish a lot of important things. For example, it might be a way to educate the court about the case, or educate the court about the client. It's also an opportunity to educate the court about the opposing party and their lawyer. You can also lay groundwork for the themes that you're planning to develop throughout the case, and learn about the opponent's themes. And importantly, it's an opportunity to develop your team's credibility and undercut the credibility of opposing counsel. Good motion practice requires careful planning and good judgment over basically 4 stages. First, setting up the dispute. Second, meeting and conferring. Third, briefing. And last, oral argument. I will talk about some of the best practices in each of the 4 stages. There's no way to hit everything, but I've provided an overview here to give you an idea of the analyses you should be doing as part of motion practice. Turning first to setting up the dispute. You need to know when and how to pick your battle. Not every motion should be pursued or pursued at that point in the case. Some motions are critical, of course. Dispositive motions, motions to compel the discovery of key evidence, and Rule 12 motions are all examples of this. Some motions, though, are better not brought if you can help it. For example, a briefing schedule or an obviously one-sided discovery dispute. Courts generally expect counsel to work out those kinds of disputes, so if you cannot, the court may declare pox on both your houses and conclude that both parties are a problem. Now, these are generalizations, but in every case, it's important to consider whether you have a truly good basis for your position, or if you can't work it out, whether you should at least seek to narrow the dispute or position it to where the other party looks unreasonable in the resulting motion practice. There are several factors to consider when strategizing about a potential motion. One thing that's always good to consider is there a glass house problem? Meaning, will the motion actually create an opportunity for opposing counsel to discuss similar or worse conduct by our client, or to ask for relief that our client wouldn't want to be forced to provide? If so, you might want to stand down or negotiate a resolution. Note that thorough legal research may be needed at a relatively early stage so you can fairly assess how the court would likely rule. Knowing the ultimate merits of your position is important to determining how to posture your client and its position in the dispute so it's the one looking reasonable in the end. Step back and use common sense. Is the prejudice you're wanting to argue to the court real and there's no other way to address it? Is there some creative solution here that would resolve or narrow the dispute? Is there a solution that might sound really good to the court but is actually problematic in some way? You should be ready to explain why that is. Part of this process, of course, involves good counseling with the client who may want to press a dispute even when its position is weak. First, it's helpful to thoroughly explain the merits of the motion and of the opposition. It also helps to explain where the motion stands among other options in the case and the relative merit of those options. Second, I try to spell out for the client the implications of the various courses of action as much as I feel comfortable with. It's helpful to the client to understand all the likely implications so they can have meaningful input into the process. And it can be disappointing to them if a particular course of action leads to a result they didn't expect. Third, it can be helpful to explain the case dynamics. For example, how a given motion might be weak and make the client appear desperate or cause them to lose credibility before our decision maker. Some thought should also take place early on as to how the motion should be positioned. For example, in one recent case I had, my opponent undercut his own position significantly by taking a super aggressive, almost nonsensical position, maligning me and our clients personally, all in a case where his clients are alleged to be bullying our client. And this point was not lost on the court. Turning now to meeting and conferring. Meeting and conferring is not just a box to check, and it should not be treated as one. Why is that? First, courts want to see parties really try to resolve disputes out of court. If the court believes the parties didn't try hard enough to resolve issues, it may send you out into the hall to work it out, but whoever brought the motion will probably not be thought of kindly by the judge. Proper meeting and conferring is also important because it can result in actually resolving at least some of the issues in dispute and may narrow the scope of what the court has to deal with, thereby simplifying the busy court's job. Even where it does not resolve the dispute, good meeting and conferring can serve to educate the parties on their opponent's position, which can generally lead to higher quality briefing. As to meet and confer letters, I'll describe an approach we often use. As the moving party, we prepare a pretty thoughtful and fairly detailed letter before the meet and confer to put the other party on notice of our client's position and our rationale for that position. The object is to give opposing counsel every opportunity to understand the error of their ways and accept or move toward our position. This way, if they don't, we can show the court that we really tried to resolve it, and unreasonable opposing counsel just wouldn't come around. Part of giving opposing counsel this notice is actually providing them with a reasonable period of time in which to both prepare a response and also to find the time to speak with us. We also want to learn as much as we can about their opposition points, so we want to give them sufficient opportunity to think through their position. Usually a week will do it. It can also be helpful to offer opposing counsel a wide window of time in which to meet and confer, so that it's harder for them to avoid having the meet and confer with us in a prompt time frame. So I may offer them the better part of a couple of full days. It's not a problem for opposing counsel to prepare a detailed response letter, as long as it's produced within a reasonable time period. This response is helpful because then we can better understand the opponent's position, and the opponent can't suggest that they were unprepared to meet and confer with us. Beware, however, of lengthy letter campaigns. Letters rarely solve anything by themselves, and they can waste a lot of time and money. Finally, in the event that counsel refuses to meet and confer, we make sure to create a record showing that we gave them every opportunity to do so. The meet and confer itself should be taken seriously, and real preparation should go into it. Talking through the issues may help to clarify the opponent's position, which may not be clear from the letters, and create real opportunities to narrow the dispute. Therefore, discussing the merits of our client's position in some detail and taking the time to thoughtfully counter the opponent's positions and fleshing out the weaknesses and strengths in the parties' relative positions is usually time well spent. Some opponents will actually attack you for trying to do this because they would prefer not to engage you at that level. But that usually tells us they are weak on the merits. Ideally, they will engage, however, and you will either narrow the dispute and/or learn useful information for the briefing process. The most significant outcome of the meet and confer is to ensure that our own position is as defensible as possible. Should we narrow the scope of what we're asking for or broaden what we're offering, if we're not sensitive to that, the court may ultimately reject our position or think we're overreaching. And therefore, the court may question our credibility, which is something we really don't want. Meanwhile, we're proposing solutions that we believe are reasonable so that if opposing counsel continues to resist, we can hopefully show that it's the other party that is unreasonably resisting and is therefore the problem. Dealing with difficult opposing counsel can be both a curse and a blessing. In this regard, and where opposing counsel is really being a problem, it can be helpful to have a meet and confer recorded by a court reporter or to ask the court to actually order it. In one case recently, the court ordered this, and so this enabled us to elicit our opponent's unreasonable positions on the record. Meanwhile, we were proposing reasonable solutions for him that he inevitably and arrogantly dismissed. Then, with the benefit of this written record, we could quote his statements back to the court. This was so effective that eventually he was dismissed from that role on his team, and the court noticed this fact. Also, using that record over time, we were able to demonstrate our opponent's consistent pattern of resistance and how it actually revealed that the opponent lacked factual support for its position in the lawsuit. This paved the way for a great settlement for our client. Turning now to excellent briefing. Killer briefs are a topic unto themselves, but I will hit some high points here. First, preliminary statements are very important. A strong preliminary statement, as opposed to an introduction, should be at the front. It should provide a reasonably succinct and accurate summary of the main points, such that the court could actually rule in your favor even if it only read the preliminary statement. Statements of fact should be completely accurate and have good support. They should not be too argumentative. It's okay to limit the facts to those relevant to the motion and to providing context for the motion. Also, there's no need to include all of the facts that you need for the motion in the statement of facts. Some may be better appearing for the first time in the argument, so that your statement of facts is a nice, cohesive story without off-point details distracting from it. Also, cite all material facts properly. Uncited statements are not facts, and you don't want the court to conclude that your argument lacks support. This brings us to the use of authority. Ensure that your motion is based on solid legal research. Doing good research in advance may help you to recognize and develop and cite useful facts, and help you to determine how to most effectively structure your argument. Using authority effectively requires actually reading and understanding all of the cases cited. All the time, we find wonderful nuggets in the case authority that we can use. Reading the cases may identify or develop new supporting arguments. It also allows you to find and use the best quotations. So often, counsel uses quotes that are decent when there's really a much more powerful one in the case they're citing. Don't lose this opportunity. This brings us to the mighty parenthetical. The parenthetical is one of my favorite tools in the briefing toolbox. Parentheticals should be accurate, smart, and concise, and when strung together, they can quickly confirm to your reader that there is ample case support for your proposition. Carefully choosing the words to use in each parenthetical to show that the quoted statement applies perfectly to the case at hand, especially when a number of these are strung together, can have a very powerful effect on the reader. I'd also like to touch on brief length. There is a reason that it's called a brief. Most of them could be more concise. It is to one's benefit to organize the arguments well and not clutter them up by trying to respond to every point raised. Use headings and subheads to clarify the argument. Now, where there's irrelevant matter in the opponent's brief, say extraneous argument, something that's going to distract the judge perhaps, your responding brief should maintain focus on what matters and then find a way to dismiss or demonstrate the irrelevance of the unmeritorious arguments of your opponent. Sometimes irrelevant arguments can give you an opportunity to demonstrate the opponent's desperation or dishonesty, such as where counsel has suddenly abandoned his strategy in opposing your brief in favor of a new one midstream. But you need to think carefully about how to deal with this. If it's very material, I might highlight it immediately and make it the theme of my brief. Where it's less material point, I might note it gently in a footnote. I also take time to really study the opposing party's materials. Of course, I look at what's actually in those materials. I read them carefully. I look for any admissions or other helpful statements. And I look for purposes of the entire case, not just the motion. Sometimes the people writing these are forgetting the forest and the trees. In many jurisdictions, judicial admissions made by someone cannot be contradicted later, and thus may determine a portion of your dispute in your favor. Sometimes a litigant's position as to the law or the facts, or as to the relief requested, may be objectively unreasonable or simply false, and it will be difficult for him or her to walk away from these statements later. Also important is what's not in the briefing or the supporting declarations. Did the opponent concede something outright, or concede something by failing to respond to a point we made? Some time may have elapsed between your motion and receipt of the opposition. And even if not, it can still be useful to go back and read your own motion, taking careful note of which points were made but never responded to. Also, I scrutinize the language chosen in the brief or in the supporting affidavits or declarations. Is it really carefully chosen to make a misleading statement true? Are there qualifiers in there because the same conclusion could not be drawn without them? You've got to read between the lines. The tone, of course, is very important. Keeping the tone of the briefing professional is absolutely necessary. In the heat of battle, this can sometimes be difficult. I suggest using the passive voice, removing adverbs, suggesting rather than accusing. These are all ways to make your point without looking like a jerk or a bully. Histrionic or hyperbolic statements don't help. If you overdo it, the court may conclude that your judgment isn't to be trusted. Also, be particularly tempered in your approach to an opponent's misconduct or dishonesty. Make the facts speak for themselves. In some cases, you might wait until the conclusion you want the court to draw is really apparent. Give them enough rope to hang themselves, in effect, rather than addressing it prematurely. Avoid ad hominem attacks. And also avoid accusing someone of ad hominem attacks. Often, opponents will literally make an ad hominem attack on me while in the process of accusing me of having done so, when in fact, I have only pointed out something they said or did, which of course makes them look like a bully. Oral argument. Of course, books have been written about this subject, but here are a few thoughts. In my opinion, the ideal oral argument is short and sweet, a surgical strike. Hopefully, my brief has been so well organized and written that it's a clear win. Sometimes I can just get up and make a few key points, destroy the rest of the opponent's credibility, or clarify or emphasize certain points so the court will remember them. You can and should try to do some research on the judge's analytical style ahead of time, but one should always be ready for the possibility that the judge may not be fully prepared or didn't understand some of the briefing. Or maybe they just want a quick summary. So I usually have an outline ready for that. For my more targeted argument, I usually make up a simple summary of the material points that I need to cover and a summary of the opponent's points and my planned rebuttal to them. Now, where the briefing resulted in a changed landscape, meaning where certain disputes are now resolved or where an important point was raised but never rebutted, it can be helpful to point those things out so that the judge will spend his or her resources on the remaining items that are actually still in dispute. Material new information that came up post-briefing should be brought up, but beware of surprising opposing counsel. I recommend letting opposing counsel know that you're going to bring it up in advance so that you don't get shut down by the judge. It's easier to be able to tell the court that we let opposing counsel know well in advance that we were going to raise this argument and they should have been prepared for it. Usually, the opponent doesn't do much with the advance notice. Charts and other visual presentations can be helpful. We might use visuals to help us summarize information, to emphasize certain points, or simply remind the court of the greater context of the case and where the motion fits into it. Importantly, after all the briefing is done, in preparing my outline, I step back from it to take a big picture view, and that can sometimes reveal the very best points for me to make an oral argument. For example, was there a subtext in the briefing? Something else going on, some long-term or unexpected implication of the decision here? What statements demonstrate that opposing counsel has been less than forthcoming? Is there a more common sense or less prejudicial way to deal with an issue than the one our opponent is insisting upon? What is the impact on the case schedule? Will it delay things? There are so many examples of important points to make that virtually leap off the page well after everything was briefed. Jotting down notes as opposing counsel is speaking during the argument can help you remember the points that you want to rebut with. They may talk for a while, and you don't want to forget anything. Also, being well prepared with your affirmative points permits you to quickly and decisively make them, or to use them for rebuttal. In conclusion, following these steps will result in better, more targeted, more effective motion practice. Judges and clients will appreciate it because good motion practice helps to narrow the scope of the disputes that must be resolved by the court, which is typically busy and wishes people could just get along. Good motion practice helps make decision-making easier for the judge. Also, by narrowing disputes and enhancing the meet and confer process, these steps create more predictability around litigation results. Thoughtful motion practice also helps the court understand what the case is about and what the parties are about, and helps to set themes for the case. It also begins to establish with the judge your credibility and that of your client relative to that of your opponent. If you would like to learn more about excellent motion practice, see my 2-part daily journal article on my webpage. Also, I encourage you to learn more about our firm at quinnemanuel.com.